Hey, thanks for making us part of your long weekend. The federal government is proposing changes to strengthen Canada's bail system. Bill C-48 was introduced this past week. If passed, it will become harder for violent repeat offenders to be released on bail. The bill also expands the use of reverse onus. That means the accused has to show why they should be released instead of prosecutors having to prove why they should stay behind bars. The Conservatives have criticized the measures.
The Randall McKenzie, who is the accused killer of Constable Pershella, already had to overcome the policy of, already had to follow through and prove the onus on him to be released. And he achieved that. So he was released, even though there was an onus on him to prove that he should be. In other words, he would have been released by this regime, the catch and release regime the Liberals are reinforcing.
Earlier, I spoke to the Minister of Justice, David Lametti, about why Bill C-48 is needed and whether he thinks it should have or could have gone further. Minister Lametti, thank you for making the time. Appreciate it.
That's my pleasure. Thank you.
As you know, violent crime has gone up about 32%, just over 32% from 2015 to 2022. That is, of course, the time that your government has been in office. Why do you think there has been that serious increase in violent crime offenses?
Well, first of all, the statistics are unclear. There's certainly been a decrease over the last 20 years, but there certainly is a perception, at the very least, of an increase in violent crime. We've just come out of a massive pandemic, massive upheaval that has had an impact globally. That's had an impact on people's mental health. It's had people cloistered in small spaces or homes for long periods of time, and we've come out of that, and it's really put a lot of pressure on a number of different social fronts, if you will, housing, mental health, etc. And I think we're seeing the impact of that, to be perfectly honest with you.
Yeah, the chiefs of police and largely the provinces were pushing for these bail changes. Are you doing this because of public pressure? Because it wasn't something you seemed to be considering before that.
Well, it's certainly something that we pay attention to. We do all criminal policy reform, criminal law reform, working with the provinces because they're the ones who administer the system of justice. Sure. So whatever criminal justice bill you have seen from me or my predecessors, it's always been something that's been worked on with the provinces. This is something that we identified in October. It was British Columbia that first raised it at a federal provincial territorial justice ministers meeting. They said, and it was former colleagues in the House of Commons. It was Murray Rankin, who was the minister at the time, who said we need to look at bail. And so we began looking at bail. Then, of course, we had the tragic death of Constable Pershella in December, a number of weeks after that. And I guess that accelerated the push. But it's certainly something that we looked at collaboratively with other justice ministers, with police associations. We listened to them. We listened to stakeholders. We listened to victims' rights groups. We did our homework on this one quite carefully. And I think we've come up with a bill that addresses the concerns that were raised.
And yet some people, including law professor Gennaro Jones, who I'm sure you know, says that the legislation speaks to, quote, hysteria dressed up as legitimate public safety concerns, that this is really about responding to headlines and particular incidents as opposed to a comprehensive bail reform that would make sense. What do you say to that?
Well, I don't think that's true. Certainly, we had done comprehensive bail reform in Bill C-75, and that remains in place. Again, that was done in close collaboration with the provinces. This is, I suppose, an adjustment of something that was raised not in Bill C-75, but was raised by, again, police associations and justice ministers about repeat violent offenders. And again, that's a serious concern, and that's what this bill targets. So it's targeted reform. It's narrow reform. Yeah. It's not meant to be comprehensive. We did that in C-75, but it is something that we addressed because it was, I think, quite legitimately raised.
Is it not an admission then that C-75 was not a success, that you had to come in and put this piece of targeted reform in place that C-75 didn't address?
No, I don't think so. C-75, it basically enshrined a number of principles that had come from the Supreme Court of Canada and Supreme Court decisions And it allowed us also to attack the problem of lesser offenses. The administration of justice offenses, where we were wasting too many resources on non-serious matters by incarcerating people, and it allows us to concentrate on serious stuff. We also added serious reverse onus on intimate partner violence in C-75, and that was very important.
Are you concerned that people, because of that expansion of reverse onus, that people will not seek bail, or that fewer people will seek bail, which is, of course, something they have a reasonable right to? I wonder how you make sure that that doesn't happen, that people do understand that they still have the right to request it and to try and get it.
Well, they have a right to get it, and in virtually all cases, it will still be the case that the Crown has to show why they shouldn't get bail, right? There have to be a flight risk or a threat to public safety, or will undermine confidence in the justice system. That's still the standard case. Sure. What we've done here is targeted a really narrow set of offenses: repeat violent offenders with a weapon. 3 criteria there, and then offenses linked to firearms, and so these are very legitimate concerns that were raised, but it's only that narrow band, and so by staying in that very, very narrow lane, we feel we're quite compliant with the charter, but we're also addressing a number of very specific needs. And this didn't just come from police associations. I was out in Manitoba and met with one of the main Indigenous leadership groups, and they mentioned knives, they mentioned machetes and knife violence, and so we're sensitive to that.
Well, I'm glad you brought up Indigenous groups, because you did say that you want to make sure it doesn't make things more difficult for Indigenous offenders or people of color and who are generally overrepresented in the prison system. How do you make sure that happens, and how does the justice system balance the GLADU principles with what you're doing here with C-48?
Well, thank you. Great question. Well, first of all, one of my priorities is to reduce the over-incarceration of Indigenous and Black and other racialized Canadians in the criminal justice system, and certainly we're working on larger Indigenous and Black justice strategies to identify systemic racism in the system. So that remains an overarching priority for me, and I hope that nothing that we're doing here goes against that. The answer is the same as the answer I gave before, which is by staying narrow, by staying targeted, we're focusing on a really narrow band of offenses, so that we hope that this will, and we're confident actually that this will not really upend the other good work that we're doing with respect to fighting systemic racism in the system over representation of Indigenous peoples. With respect to GLADU, I mean, look, there is it is again something that I think Canadians believe in, and I think the Supreme Court has clearly enunciated in the GLADU case that we need to take the indigeneity of offenders into account at every stage in the criminal justice process, because it might have a bearing, it ought to have a bearing on how we address the reasons which cause this person to offend. So that remains.
As you know, Pierre Poilievre says that this doesn't go far enough, that this actually just puts different sort of criteria underneath the bail conditions instead of making them tougher. What is your response to that? I mean, could this have gone further and stayed within the charter parameters that you have to work with here as well?
My honest answer is I don't think you can go further. Mr. Poilievre also said that he wanted to charter-proof his bail reform. Charter-proof? The only thing that I can think of to charter-proof it is to use the notwithstanding clause. And if that's what he's saying, then he should tell Canadians outright, you have a constitutional right to bail. It's in the charter. It was a common law right as well. You're innocent until proven guilty in our system. And so the only way to create a reverse onus, as we've done, is to do it in a very narrow and targeted way. That's the only way it will withstand charter scrutiny. It's a very narrow margin to work within. We are confident we're within that margin. What Mr. Poilievre seems to be proposing, again, and it changes, is that he wants to go even further. I can't see how he can do it.
A couple questions about foreign interference, if I can. There are some reports from the Globe and Mail around a Section 21 warrant that was issued for Michael Chan. I'm sure you won't get into the details of that. So I'm instead going to ask you about that kind of information being leaked. It's my understanding that that's a very few number of people that would know anything about a Section 21 warrant. And I wonder, from your perspective, what the government should be doing to get a handle on these kinds of breaches of intelligence, this one that seems far more serious than previous ones, perhaps.
Well, you're correct to say that I obviously can't comment, other than to say that I'm very concerned about these kinds of leaks, that these kinds of documents might be out in the public domain or in the hands of individuals, Canadian or not. And so we do need to find out how to better secure these kinds of documents and the processes in which these kinds of documents are exchanged, and we need to look at that quickly.
Okay, Minister, we'll leave it there. Thank you for your time.
Thanks very much.